Hello, I'm Tom Giordano, and I'm the head of Lehocky Disability. First, I want to thank you for being our client. We realize you have a lot of options out there, and we are grateful to have you as a client. By now, you've waited a very long time for your hearing before an administrative law judge. We appreciate your patience and can imagine that it's been a pretty anxious time for you, waiting for this hearing and wondering what to expect. First and foremost, know that the judge who will be hearing your case has all of your medical records and has reviewed them. Your job at the hearing is to simply let the judge know how your medical conditions affect your daily living. Each judge handles his or her courtroom differently. Some will allow your attorneys to present a brief opening statement, others will not. Some judges will start to question you directly, others will allow your attorney to start the questioning. No matter which judge your case is assigned to, rest assured that your Lehocky Disability attorney will know their specific likes and dislikes and will act accordingly. You can expect to be in the hearing from anywhere from 30 minutes to an hour and a half. Present at your hearing will be your attorney, the administrative law judge who will either appear in person or on a TV screen, and a court reporter who is recording your testimony. It is extremely important that when you are testifying, you do your best to keep your voice up and wait for the judge or your attorney to finish the question before you answer it. And remember to speak with real words. Uh-huhs or uh-uhs or shrugging your shoulders like I'm doing now or making facial expressions will not be recorded. Also present at the hearing, whether it be by phone or in person, is a vocational expert. A vocational expert is impartial and has no interest in the outcome of your case. The job of the vocational expert, or VE as we like to call them, is to testify before the judge about the work that you've performed in the past. Once your past work is identified, the judge will proceed with hypothetical questions for this vocational expert. Now, we all know that the hypothetical questions are really based on you, your conditions, and your work history, but that's okay. We'll let the judge call them hypothetical. The judge will then begin to list limitations in performing certain work activities and ask the vocational expert whether work exists in the national economy that a person with those limitations can perform. Generally, the VE, or vocational expert, finds some jobs that a person can perform. Do not be alarmed. Just because the VE said that these jobs are available does not mean that you can actually perform them. The judge will ultimately decide whether he or she thinks you can do those jobs, but not before your attorney cross-examines the VE about the jobs identified. Your Lehocky Disability attorney will ask the VE questions to demonstrate to the judge that the jobs identified do not fit a person with your limitations and that your limitations are such that you would not be able to perform those jobs on a consistent, everyday basis. The VE testimony is typically performed at the end of the hearing. Now I wish to discuss the most important part of your hearing, your testimony. First, let me give you a piece of advice that I have shared with every client whose hearing I attended over the past 15 years. Do not be nervous about your hearing. You are not on trial. This is not like those shows you see on TV with yelling and screaming. And remember, you are testifying about something that you know a lot about, you. If you listen to the question that is being asked and simply tell the truth, you've done everything you need to do. And don't forget, the judge already knows about your medical background. You don't have to worry about remembering dates or treatments or other medical terms. You simply need to relate to the judge how your medical issues impact your daily life and activities. Your attorney will be with you the entire time. Rest assured that he or she will ask you every question that needs to be asked. If one of your answers appears confusing, it is our job to help you clear it up. Now let's go over some questions that you will be asked. Typically, hearing questions fall under one of three categories. The first are basic background questions. Under this section of questions, we may ask your age, your height, your weight, the highest grade you completed in school, whether you have any children under 18, and most importantly, are you caring for those children? And what does that caring entail? Now, many times, a judge is inquiring about this to see how much you actually do for your children. If you're a full-time caregiver, a judge will likely feel you can perform some type of work. It's during these types of questions that you must be sure to tell a judge how you feel after caring for your child. For example, if you're cooking dinners for the family, how do you feel during the meal prep? Do you need to sit down or take a break? Other background questions that we may ask are, what's your current source of income at the present time? Whether you have a driver's license, and if so, do you drive? How do you get around? Where do you go? Have you gone on any long trips recently? The next type or section of questions is work history. Many judges will want to know the types of jobs you performed over the past 15 years. Importantly, the judge will want to know whether you performed the job standing up or sitting down. How much walking was involved? What was the heaviest weight that you actually lifted at this job? Typically, the judges are trying to classify your job into certain exertional levels. Was it a sit-down job? Was it a physical job? One of the most important questions during the work history section is, why did you stop working? Were you fired? Were you laid off? Did you stop because of your medical conditions? You should be prepared to explain any issue with how you stopped working. The third section or type of questions we'll ask you is, what exactly is preventing you from working a full-time job? This is where we want to know about your medical issues and your symptoms. And what are your daily activities, and what limitations do you have with those activities? This portion of your testimony is most critical. It will focus on the most significant medical issues keeping you out of work. We understand for many of our clients, this is often the most emotionally difficult thing to do, especially if you're dealing with mental health issues. It can be embarrassing to discuss such problems in front of a judge. I completely understand that. But the most important thing you can do is be as open and honest during this time as possible. You do not want to leave the hearing wishing you've told the judge more about what you were dealing with. So let's go over some of the questions that you may be asked. Describe your pain using a 1 to 10 scale. 1 being no pain and 10 being pain so bad that you have to go to the hospital. What does your pain, if you have pain, feel like? Describe it. Not simply saying it hurts, but describe how it feels. Is it burning? Is it throbbing? Is it stabbing? Those are adjectives that help describe your pain. Does your pain radiate to any other parts of your body? Does the pain or medical condition that you have affect you or your ability to sit? And if so, how long can you sit without pain? Does the pain or medical conditions affect your ability to stand and walk? If so, how long can you stand? Or how far can you walk without pain? As you can tell, by asking these questions, we are trying to give the judge an idea on how long you can perform activities required in most jobs before having pain. While you may not think about how long you can actually do these activities, such as sitting, standing, and walking, it's a good idea to start paying attention to your pain tolerances now. Do your medical conditions or pain affect your ability to concentrate? Have you had any surgeries for your conditions? If so, did the surgeries reduce your pain or improve your ability to function? If not, did your condition get worse? Now, if you're suffering from mental health conditions, how do those mental health conditions affect your everyday life? Do you cry? Do you isolate yourself? Do you have anxiety or panic attacks? And if you do have anxiety or panic attacks, how long do they last? Are you seeing a doctor specifically for your mental health? Are you taking medications for any and all of your pain? Do they cause you any side effects? What is a typical day like from the time you wake up to the time you go to sleep? For example, are you able to take baths or showers without difficulties? Do you dress yourself? Do you cook meals? If so, what do you make? How do you feel after you make those meals? Do you clean your house? What things do you clean? And how do you feel after? Do you watch TV during the day? What do you watch? How many hours of TV do you watch? And when you're watching, are you sitting or lying down? Do you use a computer? How long are you using a computer? And do you have any difficulties using a computer? Do you nap during the day? If so, for how long? And if you nap, do you nap every day? How many hours do you sleep at night? Do you sleep soundly, or are you interrupted by pain or other things? Do you belong to any groups or clubs? Do you go to religious services? If so, do you have any issues with that? As you can tell, I just went through a lot of questions. Some of them may not apply to your specific situation, but hopefully you can get the gist of what we're trying to relay to the judge. Your symptoms and your limitations and how they impact your ability to work and sustain full-time employment is truly the most important aspect of your testimony. Your Lehocky Disability Attorney will call you before your hearing, usually the week of the hearing, to go over these questions in detail. We will also meet with you at least 30 minutes before the hearing starts to go over any last-minute questions that you may have. Finally, here are a few things you need to know about what happens after the hearing. The judge will not make a decision at your hearing. We typically expect a decision to be made within 90 days of the hearing, but do not be alarmed if it takes longer. The judges, unfortunately, have a backlog of claims, and it can take them sometimes many months to actually issue a written decision. Also, the judge may keep the record open after you testify so that we can provide additional information, such as newer medical records or documents that address something that came up at the hearing, or maybe something the judge needs clarification on. Do not be alarmed. Our team will make sure the judge has everything needed as quickly as possible. Very rarely, the judge may wish to send you to a one-time examination as well. That's okay too. In closing, know that you will do great at your hearing. Remember, be open and honest and everything will be fine. We are looking forward to represent you before the administrative law judge. It's all we do. We truly believe in your case. That's why we agreed to assist you. Good luck.